Hello, I'm Professor Ian Flecher and I'm here to talk about my course International Insolvency Law. The course number is G150. It's a course for 15 credits and therefore is a half subject taught entirely during term 1 of the year. We meet once a week for a 2-hour seminar, and since the classes tend to be quite small, these can be as interactive as you wish to make them. In addition to the weekly classes, there is an opportunity to write a trial assessment based upon past examination questions over the Christmas vacation and to receive feedback after you've handed your written work in at the beginning of term 2. This doesn't count towards the final course assessment, but it is a useful way of measuring your performance and receiving feedback and advice from me. I teach all the classes, and the final examination, which takes place in term 3, consists of a 2-hour unseen written exam with permitted materials that you can take in. All of the materials that are available to be taken into the examination will be downloadable from the Moodle website in the course of the year. International insolvency is a subject which is unusual in that it has come rapidly to prominence in the last few years. It is in fact a very old subject that has lasted for many centuries in a somewhat dormant state. But with globalization and with the increased interactivity between commercial societies, international insolvencies have become very much a thing of the moment. The global financial crisis has, of course, accelerated concerns about what is to happen when a company has had trading interests straddling numerous different countries and jurisdictions and then encounters financial difficulties. What we discover is that the insolvency laws of the different sovereign states of the world are all very different from each other in numerous ways. Some of these are quite trivial and may not affect the outcome of a case, but others are extremely significant and can make all the difference with regard to who receives any compensation out of the matter at all. To take an example, in the case of set-off, English law makes the operation of set-off a mandatory requirement in every corporate insolvency. But many countries on the continent of Europe do not allow set-off to happen at all if one of the parties is insolvent. So when a party has had trading interests between England and, let us say, Luxembourg, the question of whether set-off will be allowed is going to depend upon whether Luxembourg law or English law governs the liquidation process. The quest to find ways in which to regularize and arrange for an orderly process has been a very lengthy one, and that is at the heart of this course, as we shall discover. But to begin with, we take the obvious step of discovering what happens in ordinary cases under domestic law when an insolvency involves contacts with more than just the domestic jurisdiction. We look at the way the English courts have encountered these problems historically and the solutions which they have devised in order to try to deal fairly with the various interests generated from parties in England and overseas. Correspondingly, when proceedings take place in one particular jurisdiction but involve parties and interests and property which are spread in different places abroad, it is a very real question how far the court's determination and the distribution of the property that the court organizes will be respected, accepted and enforced by the courts in other countries. So the international recognition and enforcement of insolvency proceedings that have opened in one place is a major part of our interest in this international insolvency course. Once we have looked at the solutions that the English courts devised more or less by improvisation in response to cases that came before them, we progress to see how statutory intervention has taken place to try to facilitate cooperation and interaction between different insolvency systems. But unilateral action by courts or legislatures in individual countries cannot really solve the problems that arise in a genuinely complex international case. It requires international agreements, treaties, conventions, and other types of arrangement. And at the heart of our course, we shall be looking at two main ways in which matters have been much improved in the last 2 decades. The first of these is at the European level, with the introduction into force of the European Insolvency Regulation in 2002. That affects insolvencies now in 27 European countries, including the United Kingdom. Besides the European regulation, the United Kingdom has also enacted a model law that was produced by the United Nations Commission on International Trade Law, UNCITRAL. And the UNCITRAL model law is in many ways complementary to the developments in Europe, but is on a truly global aspiration. So we shall see amongst the 20 or more states that have now adopted the model law how matters of cooperation have been improved between them and in relation even to cases which involve non-enacting states and parties who are based there. So this is a course which should attract people with a curiosity about how insolvency in the real world impacts upon real trading relationships that transcend individual national frontiers. In order to take the course, it is helpful to have some knowledge of insolvency law at least a basic level. It doesn't have to be English law, but it will be helpful for you to understand the basic concepts and principles that are used. It's also a course which involves encounters with the discipline known as conflict of laws or private international law, and there again it will be helpful if you have at least some understanding of the usual rules which are employed for the taking of jurisdiction, the choice of law, and the recognition and enforcement of foreign judgments. However, bankruptcy and insolvency have developed their own special variants of the standard rules of conflict of laws, and it's with those that we will be primarily interested. After we've examined the English, the European, and the UNCITRAL positions, we will take a final look at the present-day developments which are still ongoing to improve still further international cooperation and collaboration in the conduct of international cases of insolvency. And these involve organizations such as the World Bank, UNCITRAL, the IMF, and also a project in which I was myself involved for the American Law Institute. All of these we shall encounter in the course of 10 rather short weeks, as it will seem. The time flies by, but I hope that you will join me in these classes, and I look forward to seeing you at the start of term when we begin the course. Thank you for listening.